Okay, we are back. The prosecutor's rebuttal closing argument is done during the break. There wasn't really much other than essentially asking the jury, please, please, please do the right thing. I got Bernarda Villalona with me. She is a former senior homicide prosecutor in New York and an awesome criminal defense lawyer. Great guest in studio. Bernarda, welcome. It's been a long time since I've seen you.
Bob, thank you for having me. I'm excited about being on with you and Neama, of course.
Yes. So listen, I got to tell you, I've been saying to the audience, and in case people are joining us, I'm fawning over this defense attorney.
Absolutely.
I want an action figure when it comes out. As a trial lawyer myself, and I think I'm pretty good at what I do,
Bob.
She made me think twice about my own skill set. I'm serious.
Let me tell you, she's definitely a trial attorney. Let's just call her what she is. She is a trial attorney that is experienced. And in fact, she dropped her resume to that jury. She says, I've been practicing for over 20 years and I've done over 100 jury trials. So she let that jury know exactly what her background is and that she's more than capable and being honest when she's explaining the case to that jury as to why they should find reasonable doubt in this case. So she definitely has credibility.
Yeah, we talked about how the prosecutor just basically shut down Bernarda. If you were looking at like you just sat there kind of like this. So she slipped that bad boy in about her experience, which typically would be objected to, but it wasn't. But she's just really, she thought that she's got all that skill. And Neama, we were talking before, you know, I was watching even critically when the rebuttal was going on, and I just want to get into this dynamic. You guys, all former prosecutors, so, you know, we know the game. Sometimes when you're co-counseling in that environment, there becomes kind of like an agreement, like I'll do the opening and you do the closing. And homie didn't play that way when I was doing it. I'm like, I'm doing the opening, I'm doing the closing, I'm doing the cross. And sometimes it sounds egalitarian, but not necessarily the best thing for the case. I'm not trying to come down on these guys. What I'm just trying to say is that this defense lawyer is a force of nature, and the first prosecutor, Mark Sleeper, did a pretty good job with what he had. Do you think that dynamic went on there, and it would have been better if Sleeper had done the rebuttal argument?
Probably, Bob. And back in the day, a lot of judges wouldn't allow you to split up the closing like that. Whoever did the opening argument had to do the rebuttal. But things change over time. Now you see judges allowing this type of split. Some judges even now allow a mini opening before voir dire, before the real opening statement. So these are the types of things that kind of evolve over time. But generally, I agree. I like to do the rebuttal if I'm doing the opening argument, if I'm a prosecutor.
Yeah, Bernarda, I'm pretty confident knowing you that you weren't going to suffer fools lately. If you want to do that closing, you were going to be doing that closing.
Exactly. You got to do what's best for the case. It's not about your ego. So as a prosecutor, you do what's best for the case. If you're the strongest person and appeal more to that jury, then guess what? Who should be closing? That person. Not about egos. You're there to get justice. In order to get justice, you need to do what's best for the case. And that didn't happen in this case.
Yeah, and I want to be fair, Bernarda. I want to listen to the prosecutor's rebuttal because they were on their heels. Now, it doesn't mean they're not going to win the case. Sometimes the evidence will just overwhelmingly, you know, push a guilty verdict.
But that's not the case, Bob, here.
But that's not the case here, right? But despite the fact the lawyering can make a big difference in a close case. And what I found interesting was that, and I would not have gone there, and I'm not the all-seer of trials. I mean, maybe you see it differently. It was just basically him trying to explain why he's not as good a lawyer as the defense lawyer was. I'm not theatrical, I'm not this, and he wasn't tying any, in my mind, any of the statements he was making. I was listening to them, but I'm like, bring it home. What's the point to what you're saying? Did you feel the same way when you were listening to that?
No, exactly, because he was giving excuses for his performance. Look, in reality, since that's a state that you're allowed to give a rebuttal as a prosecutor, because you know here in New York, you can't give a rebuttal when you're talking about doing a closing argument in a state case, because the defense closes first and then the prosecution closes first. But he was giving excuses for his performance. But what he should have prepped is that his rebuttal should have been ready before the defense even summed, because if you shouldn't be responding at that moment, taking into account what is said, you should have been able to see that ahead of time and been prepared to respond, because you know the issues in your case. You know what the jury is looking for, and you know where your weak points are, so you should be ready to address it as opposed to just responding to what the defense is saying.
Yeah, Neama, to Bernarda's point there, I mean, what I heard a lot, and again, I'm trying to be fair here, was that he was responding to her closing, but in essence, when he was doing that, he was repeating her closing arguments to the jury. What were your thoughts?
I agree with Bernarda, and I usually agree with Bernarda. But look, if you are doing the rebuttal and that's all you're doing, you better be prepared. You know what the defense is coming at you with. That's why it was scattered all over the place. And again, another mistake by the state of Ohio, the biggest one of which was putting in the defendant's entire statement in their case in chief. They pretty much started with that. So that really made it so the defendant didn't even have to testify in this case and really be subject to cross-examination. A huge mistake there. And the same thing, you don't want to be repeating the defense arguments in your rebuttal. You want to be pounding your strong evidence, those facial fractures, the fact that the defendant is seemingly a liar. And when you're kind of bouncing around and doing this type of thing because you want to address everything, you're really addressing nothing. So I didn't like the rebuttal.
I want to highlight and underscore what you just said because we have a lot of true crime aficionados, lawyers that watch the show. I've said this as a prosecutor many times when I was training or going over a case with a younger, usually less seasoned prosecutor. Just because you have a statement doesn't mean you need to introduce it, because you're introducing the defense. If you don't use the statement, you're going to force the defense in many instances to put the defendant on the stand. Now, if you definitely need it, then maybe you have to do it. So, I mean, we'll give them the discretionary judgment call on that. Anyway.